Jen Crane, and I am an estate planning and special needs attorney with Odin Feldman Pittleman in Reston, Virginia. I'd like to thank the ARC for hosting me today to discuss the basics of estate planning. Now, why are we starting with this topic in our series of webinars? The answer is pretty simple. Most special needs planning takes place in the context of estate planning. So it's important to have that framework in mind when we discuss special needs planning. It's very easy to think, I have a special needs child. I don't need to worry about myself. I'm just going to worry about planning for them. But thinking in that type of vacuum actually does a disservice both to our special needs children and to ourselves, because estate planning is a comprehensive subject. We want to walk through each of the documents that we need, and we want to discuss the ways in which those documents facilitate the special needs planning requirements for our children. So today we're going to get down to basics, and I'm going to discuss the staples of life care planning documents and estate planning documents. Then at the end, I'm going to anticipate the questions I think most people will have. Should you have follow-up questions, you're more than welcome to contact me. My email address is Jen, Jen, .crane, CRANE, at O as in Odin, F as in Feldman, P as in Pittleman, law.com. Jen.crane at ofplaw.com. Let's get to it. So we want to talk about life care planning first. Those are the documents we need in place should we need a decision maker while we are alive. I'm talking about powers of attorney. Now, it's important to note that powers of attorney are only in effect while we are alive. That's because a power of attorney is a document whereby the principal, the person granting the authority, gives to the agent, the person receiving the authority, the ability to act on the principal's behalf. That agency can only flow while the principal is alive. Now, we're going to discuss a couple powers that supersede death. That means override death or continue after death. But for the most part, we want to think of powers of attorney as documents that are only effective during our lifetimes. The first document we're going to discuss is a durable general power of attorney. This is the document that allows an agent to do all the things we do for ourselves every day that are not medical. So a durable general power of attorney is everything that is not medical. So for that type of document, there are two types. And this really is true of almost any type of power of attorney. There are basics and there are springings. A basic power of attorney is effective the moment that it's signed, so that your agent can start acting for you right away. A springing power of attorney requires a doctor's certification of incapacity before your agent is allowed to act on your behalf. Now, it's important to know whether you have immediately effective or basic powers of attorney or springing powers of attorney. Springing powers of attorney used to be commonplace, and a lot of folks don't even recognize that these are the documents they have because honestly, they never read their estate planning documents after they left the attorney's office from signing them. But springing powers of attorney that require that doctor's certification can be a real impediment to our agents acting on our behalf. Why? Well, if your document requires one or even two doctors to certify your incapacity before your agent is allowed to act, that means we've got a roadblock before that action can happen. And if we're looking for a certification of incapacity, one thing we're seeing routinely is that regular general practitioners are refusing to perform capacity evaluations and instead are requesting neurologists to complete them, not thinking themselves qualified to render an incapacity determination for a legal document. That being the case, if any of us have ever tried to get one doctor to do something, try potentially getting two doctors, and not just regular doctors, neurologists, most of whom have a waiting list a mile long. Powers of attorney are only as effective as they are in practice. What do I mean by that? Doesn't do me any good to have a power of attorney if there's a roadblock to it being used. So for a financial power of attorney, a durable general power of attorney, I want to make sure that it's immediately effective. Now you're probably saying to yourself, why would I ever want a springing power of attorney? And I'm saying the word springing like a bunny's springs. Springing powers of attorney used to be used where we wanted to ensure no one was going to act on our behalf subsequent to the authority granted under a power of attorney without our knowledge. Powers of attorney are terribly powerful documents. One thing I routinely advise clients when we're meeting is that when you are selecting a fiduciary is any person who stands in your shoes to be of service to you and acts only for your benefit and not in their own self-interest. A lot of times, folks wanted to make sure they had a built-in protection that that agent couldn't step in, couldn't do anything absent there being an intervening event, like a declaration of incapacity. But one thing I've routinely believed and shared with clients over 17 years of practice is that if you don't trust your agent not to act unless they need to, you don't want to name them. You know, one tenet of estate planning is you have to feel comfortable with your attorney, and you have to feel comfortable sharing your deepest, darkest secrets. I routinely tell folks I'm the only total stranger they're ever going to meet who's going to ask them completely inappropriate questions, with the understanding I'll never repeat a word of it, but that if they're not honest with me and the questions I'm asking, I can't adequately plan for them. So when we're talking about agents, the people who are going to act for us under a general, durable power of attorney, we need to talk about trustworthiness, credit issues, bankruptcies, things like that. If an individual can't manage his or her own finances, they shouldn't be acting for us. Serving as an agent under financial power of attorney requires detailed record keeping. If someone is overwhelmed by keeping their own finances, they're definitely going to be overwhelmed by keeping someone else's. So it's important to have these conversations. Now, another thing to look for when we're talking about powers of attorney is the word durable. What do I mean by that? Well, back at English common law, powers of attorney ceased on incapacity. That meant they were only effective insofar as the principal, the person granting the authority to an agent, was capacitated. Well, we need powers of attorney when we're not capacitated. So that word durable means survives incapacity. If we should become incapacitated for a variety of reasons, that power of attorney remains in full force and effect. So you've pulled your power of attorney out, you're looking at it, you verified it's immediately effective, you verified it's durable. Now we're going to ask that you verify the agents you have named are alive. Now, I hope that elicited a chuckle or two, but it's a very real question. We want to make sure that the document can actually be utilized by somebody. If the agents are no longer with us or are not willing to serve, that document doesn't do us any good. In addition to making sure our agents are appropriate choices, one thing I always ask is, have you spoken to your agents to make sure they are willing to serve? If they're not willing to serve, they do have the right to decline. Service under a power of attorney is not mandatory. No one is required to do it. And in fact, resignation is always an option. That being the case, it's important to talk to your agent. Make sure they're up for the job. Make sure they know where the power of attorney is. We've checked all those boxes. What's next? Let's make sure that power of attorney doesn't have handwriting on it. A lot of folks, when changes are necessitated, feel the need to write through the document. Well, Virginia is a stickler when it comes to legal documents, and writing through the text of a document can be treated as a revocation of the document. We never ever want to write on the face of a legal document. If changes are necessary to something substantive, you want to contact your attorney and make the changes with them. If changes are necessary for updates in address or contact information, just put it on a Post-it note and put that Post-it note right on the face of the document. Now, we've verified it's immediately effective, it's durable, our agents are willing to serve, nothing's been written on. What do I need to look for next? I'd like that power of attorney to have been executed within the last 5 years. Why? Well, under Virginia law, powers of attorney, unless they state an expiration date, don't expire. Powers of attorney are valid up until your death. And again, keeping in mind there are certain authorities that supersede death. But we're going to start talking about big banks. Banks and financial institutions are often remiss to accept powers of attorney. Reason for that is fraud. They're worried about a bad actor coming forward with a power of attorney that has since been revoked, and the agent is actively using a power of attorney that agent knows to be bad to execute some nefarious intent. Powers of attorney, as I mentioned, are incredibly powerful documents. They allow someone to stand in our shoes and take any action we could take. So banks are going to want to make sure that power of attorney has a relatively recent execution date, because banks somehow, for whatever reason, think that all folks do is update their estate planning documents. So if the document is more than about 5 years old, it's all but a guarantee we are going to run into roadblocks getting it accepted, because those banks are going to be concerned that the document is stale. Now, that's not a term of art, stale. It's not a term you're going to find in the Virginia Code. It's not a term that actively or actually does anything, but it's the term banks and financial institutions use for a power of attorney they're guessing has probably been revoked or replaced at this juncture. Now, the Constitution of the United States promises us that if a document is valid when and where executed, it is valid everywhere. As I've routinely told clients, though, do you want to pay a lawyer to fight about the Constitution, or do you just want to execute a new one with an updated date? That second option is always going to be the path of least resistance. So we've made sure it's basic. We've made sure it's durable, no writing on it. We know our agents. We know that they'll serve. It's got a recent date. We'd also like to make sure it was executed after the Uniform Power of Attorney Act, an act passed by the Virginia legislature a few years ago at this juncture that set a standard format for how these documents are supposed to look. That standard format was initiated with the hope that banks and financial institutions would be more readily accepting of powers of attorney that followed the general structure. We've ensured all of those items are met. Now we want to make sure that that document contains the powers and authorities necessary for our agent to act. There's a tendency sometimes to say in powers of attorney, I give to my agent all authorities granted under Virginia law. That's one way to do it, but it's certainly not the recommended way. We want to delineate each of the required powers, because if that power of attorney encounters a roadblock, and it probably will at some juncture, we want to make sure we can hang our hat on the specific authority that we need for your agent to act on your behalf. Your document is only as good as its acceptance. If it's not accepted for your agent to be able to act on your behalf, if it doesn't contain all the necessary authorities, it's not going to do you the good you thought it would. With estate planning, there is a tremendous presumption that once it's done, I'm not going to look at it again. I did it once. I don't ever have to touch it. Every 3 to 5 years, you want to be meeting with your attorney, looking at those documents to make sure they are valid and in full force and effect, and most importantly, do what you want them to do. I'm going to say that again, that the documents do what you want them to do. Now, in order to make sure that that's accomplished, we also need to ensure you understand your documents. I tell folks that I don't ever want a client signing a document because the papers have been jammed in front of them. Sign them because you understand them and are comfortable with them and the powers and authorities that they grant. All right, so that first document for our life care plan is our durable general power of attorney. Now we're going to talk about healthcare powers of attorney, also known as medical powers of attorney, also known as advanced medical directives. Now, estate planning attorneys do things differently, and there is no right or wrong way to tackle this. I am of the belief that having one document that does everything for a medical setting is appropriate. Why? Stress and grief do not do good things to us. If an individual has a document, one document that names an agent, one document that gives that agent authorities, one document that includes a HIPAA authorization, and maybe still another document with a living will, that part that says, don't keep me alive in the event that I'm dying, that client runs the risk that their agent, when getting the call from the hospital, something has happened to mom or dad, come quickly, goes to grab that estate planning binder, which is probably blue or red, grabs it out from underneath the bed, grabs the wrong healthcare document. They show up to the hospital with the HIPAA authorization and not the document that appoints them as agent and empowers them to make medical decisions. Because stress and grief do not do good things to us, we want to make this surefire. We want to put our agent in the best position to be able to carry out our wishes. And we do that by making sure that the document, our agent shows up with the right document. I'm just going to put it plainly. We want our agent to show up with the right document. Now, just as important as our agent showing up with the right document and our agent understanding what that document does, what it empowers them to do, is our agent understanding what we do or do not want in particular circumstances. And I can't overstate the importance of this when it comes to the healthcare power of attorney. You just heard me ramble on for 10 to 15 minutes about how difficult it is to get financial powers of attorney accepted. And we do spend, as lawyers, a tremendous amount of our time battling that battle. In 17 years, I've never had a client contact me at night or on the weekend with an emergency because a hospital would not accept the medical power of attorney. It just doesn't happen. And if you think about this, this is backwards. We should care more about the medical power of attorney that authorizes somebody to make life or death decisions for us. But unfortunately, that's just not where the emphasis is placed. So what needs to be of paramount importance is a discussion with your agent about what treatments you do or do not want in specific circumstances. I tell my clients to write a letter to their agent, a handwritten letter, not typed, a handwritten letter, and that's saying something from somebody whose handwriting is basically illegible. We want that letter to act as a permission slip so that when our agent is making decisions on our behalf, they know what we did or did not want in particular circumstances. when I first started practicing, we used to give clients a grid with 4 really depressing scenarios and 12 treatment options. We asked those clients to go through and select what treatment choices they would want in each increasingly grim scenario. And we were inputting all of this into their medical powers of attorney. And then I had a doctor as a client, and he's looking at this grid, and I am so impressed. And I think he's going to find this thrilling. And he said, "Are you doing this for every client?" And I said, "Yes, we are." And he said, no one is ever going to read this, right? At the hospital, all we look for is who's the agent? Do we have the medical power of attorney on file? If we don't have the discussion with our agent, they may not know what we would or would not have wanted. And these are difficult conversations to have. A lot of folks simply don't have them because they are so difficult. I'd strongly encourage that you sit down and have them anyway, and make sure you and your agent are on the same page about what treatment choices you do or do not want, particularly as it affects life-sustaining measures. Do you want to be placed on a ventilator? Do you want to be placed on artificial nutrition and hydration? Do you want to try those things for a period of time, and then if there is no improvement, stop? Those are important conversations to have. And it's one thing to say, my agent knows what I want, but does your agent really know what you want? If your agent doesn't, they're going to have to guess. Asking them to guess is a disservice. If they're making life and death decisions for you, the very least we can do for them is make sure they know what our intent was. And that's why I suggest that handwritten letter that acts as a permission slip. It's not legally binding. It's simply there to make the agent's job easier. Children having to role reverse to make the decision about pulling a parent off of life support is incredibly challenging. Seeing in mom or dad's own handwriting, this is what I wanted, it's okay to let me go, especially when as children, we always think our parents are invincible. I've never had somebody come back and say, "Man, that letter was a stupid idea. I wish mom or dad hadn't have done it." So I strongly encourage you to have the difficult conversation with your loved ones, with your agents, about what you do or do not want. Have the conversation about what you want at your funeral. I highly encourage you. So your medical power of attorney can authorize your agent to make arrangements for your funeral and burial, to authorize organ donation, and to authorize an autopsy. Those are 3 deeply personal circumstances. And you want to let your agent know what you do or don't want. If you do not want to be an organ donor, that's something your agent should know. If you have particular thoughts about what you want to have happen at your funeral, you want your agent to know. Oftentimes, your will include direction as to what kind of funeral you want. But the thing about a will, and we'll talk about this momentarily, a will is a piece of paper, and it's not really given any force and effect until it's probated with the local circuit court. And oftentimes that doesn't happen until well after the funeral has already taken place. The person with that authority to act is going to be your agent. You want your agent to know what you did or did not want so they can effectuate that. What you do or do not want. What if we suspect medical malpractice? Do you want your agent to be able to request an autopsy? Do you want to be an organ donor? Do you want to be an organ donor as to some but not all organs? Perhaps you only want to be an eye and skin donor, but you don't want to donate any internal organs. Those are conversations to have. The more information you can give your agent, the better service your agent can be to you. Because again, you're going to hear me say, our agents act in service to us. They are only supposed to do what we want them to do. This is also a time to suss out whether or not your agent is an appropriate choice. So for the financial power of attorney, you heard me mention We really want to make sure that person is trustworthy. No credit issues, no bankruptcies, nothing that would stand in the way of effective financial management. With the medical power of attorney, we want to make sure it's somebody who can do what we want done and not supplant our intentions with their own. If our agent is deeply religious in a faith that we do not belong to, and there is concern that that agent's faith will influence them to such an extent, they will do what their faith says should be done in a circumstance, not what we want done in a circumstance, that person may not be the best fit. When we're having conversations about naming agents under a medical power of attorney, I routinely hear a family say, I'm going to name all of my children. I don't want anybody to feel left out. I don't ever recommend this. For the medical power of attorney, we want to make sure we pick the person who's best for the job, who will show up, who will be able to do it and do it effectively. Naming a bunch of people as agents or fiduciaries so they do not feel left out is not how we show our family we love them. We show our kids we love them by giving them money, not by giving them a job they simply can't do. If you have two children, one of whom you know will simply be overwhelmed by your illness and passing, do not name them as an agent. They will simply hamstring the other agent, your other child, who is trying to act for you to carry out your wishes. I often hear my two children don't get along. I'm going to name them both as my agents because I know my incapacity and illness will bring them together. To that I say, I promise you it will not. They will continue to fight. Your document, which is only as valid as its acceptance, will not work the way you intend it to. If your agents are constantly fighting and bickering, the last resort of that hospital where you are a patient will be to say, go to court. We don't want anything to do with this. When we execute our life care and estate planning documents, the goal is to avoid court action. The goal is for our wishes to be memorialized in documents that clearly indicate our intent. If our documents not only, it's great if they indicate the intent, if they are not accepted because our fiduciaries don't show up, can't be located, are fighting too much to come to a decision, the document doesn't do us any good, especially for the medical power of attorney. Please take into consideration the best person for the job. Oftentimes, in addition to, I'll name all of my children, I get, well, I've never been particularly close with my child. I don't want them to feel left out. So I'll name the child I am close to agent under the financial, and I'll name the child I'm not close to agent under my medical so they have a job. Again, please do not do this. These documents are coming into force and effect most likely once you are unable to make your own decisions. If that's the circumstance, we cannot run the risk that the document won't work. For that medical power of attorney, I'm much less concerned about the date than I am for the financial power of attorney. For the same reasons I stated at the beginning, I've never had a medical power of attorney bounced because the date on it was too old. You want to make sure that your medical power of attorney is executed, like all of your documents, in conformity with the requirements of Virginia law. Statutory medical powers of attorney are just as prone to being filled out by form as anything else. We have statutory medical powers of attorney. That means a form that just exists in the code well before we had things like LegalZoom. Anytime you fill out a form without consulting with a lawyer, we run the risk it's done incorrectly. If that document is done incorrectly, if it is not, the fancy term is executed, it's not signed properly, it's not going to be given the force and effect we need it to under Virginia law. So it's important for all of our documents, we make sure they are signed properly in compliance with Virginia law. Another thing I want to mention about powers of attorney, but it really applies to all of your documents. You want to make sure your fiduciary, again, your agent, that person standing in your shoes to be of service to you, can access the documents. You know, that sounds like a silly thing to say, but if your agent can't get to the power of attorney, they may not be able to use it. Now, most power of attorney documents for financial and medical will explicitly authorize the use of a copy, but some institutions, financial or medical, are going to require the original. If the original is in a safety deposit box and the safety deposit box is inaccessible because it's inside a bank that's closed nights and weekends, your agent's not going to be able to get to it. One common thread I hear from folks, or one common call I get, is, I'm standing outside the bank, I can't get in, what do I do? I don't mean to be glib in these situations, but I say you got to wait till Monday morning when the bank opens. There's no secret sauce, there's no magic trick. If you're required to have the original and can't gain access to it, you're kind of up a creek without a paddle. You want to make sure your agent knows where the document is and can gain access to it. The question about whether or not to give your agent copies now is up to the client. It's up to each individual's particular preferences. I don't recommend giving the originals to the client now, to the agent now. I always recommend the originals stay with the client, because you may want to make changes and you certainly don't want an impediment to that to be, don't know where the originals are. We also want to make sure there's one original. If you've updated your estate planning 7 times, we don't want 7 powers of attorney floating out around there. Most powers of attorney will say, I expressly revoke any financial power of attorney that came before this. That's great, but it still can cause confusion if those prior powers of attorney are floating around. Anytime you update your estate planning, bring the old documents with you to the lawyer. Let the lawyer help you decide what you're going to shred, what you're going to keep, because it matters. Sometimes we do have to have the original for certain documents, and you want to let the lawyer tell you which of those, which times we need the original. It's not an area where we really want to spend a lot of time guessing. So 2 crucially important documents, part of your estate plan, financial and medical powers of attorney. Now, a lot of times, as I mentioned, special needs families are going to focus just on special needs planning for their child. And we're going to dive into that right now. But making sure you, mom or dad, have powers of attorney for yourself is crucially important. We can't forget you as a part of the planning process. So we've talked about life care planning. We've talked about agents. We've talked about principals. We've talked about fiduciaries. Now let's talk about estate planning, how we pass our money when we die. And this is the subject matter that's really crucially important for special needs families. When a family comes to me to do their planning, I break it out into 4 subsections. Estate planning for mom and dad, pause and take a breath. Capacity planning for my special needs individual, pause and take a breath. Benefits review, pause and take a breath. Transition planning, which is how is our loved one going to be cared for when mom and dad or the currently serving caregivers are no longer there. I break it up into those discrete groupings because this kind of planning is exhausting. Most people are going to want to quit at some juncture. I break it up so that we all take a breath, we can muscle through, we don't get burned out, and I break it into the most crucially important groupings first. Most families are going to come in and say, I need to do guardianship and conservatorship. You may, but that's not where I'm going to start. I'm going to start with estate planning. And here's why. We're going to take an off ramp for a second and cover some basics for special needs planning. When an individual with special needs requires special needs trust, there's two types of money that can fund that special needs trust. The first type of money is first party money. The second type is third party money. First party money is the beneficiary's own money, lottery winnings, wages, a direct inheritance. Third party money is money that came from somebody else, some money that was left for the benefit of the beneficiary, but it's not the special needs beneficiary's own money. Now, this is a 30,000-foot overview, and like all of our time together today, it's intended to be educational. It doesn't create an attorney-client relationship as between us. So now you know I'm a lawyer because I've just given you a disclaimer. It's intended to help you suss out what avenues you need to take. But as a general planning structure, we talk about first party versus third party money because first party money is subject to something called a mandatory Medicaid payback. 1993, OBRA was the federal legislation that gave us the ability to set up trusts, and state law followed. But these special needs trusts are predicated on the notion that the money is for the benefit of the beneficiary, but the beneficiary does not have access to and cannot control the money. If I don't have access to it and I can't control it, it's not mine. It cannot be counted against me for purposes of benefits determinations. Because as we know, when we have benefits, we're looking at two types, means tested and entitlement. Means tested benefits require me to be under a certain income and asset limitation. I can only have but so much money. I can only earn but so much money and maintain qualification. Entitlement benefits are eligible to me because I paid into the system or somebody paid into the system and I am eligible on their record. Now, we want to maintain benefits eligibility, and it's important to remember we can have means tested eligibility and entitlement eligibility at the same time. I can have SSDI, an entitlement benefit, and Medicaid, a means tested benefit, at the same time. So when I'm looking to estate planning, I've got to be cognizant of first party money and third party money. First party money, as I mentioned, is the beneficiary's own money. But here's where it gets confusing if you're not confused already. If that money that I leave for my special needs child, if I don't plan appropriately and that money drops like a rock to my beneficiary, passes straight down, my will says I leave my estate to my special needs son, Johnny. I just leave it like that. And there's no other magic catch-all provisions I can use anywhere else in my estate planning document. That money just became first party money. The beneficiary has the right to that money. It became his or her money. Now, under a lot of circumstances, I can catch it in a special needs trust, but it's going to be a special needs trust funded with first party money because that money was left directly to my beneficiary. It's considered a resource of my beneficiary. Now, I can catch it, as I mentioned, in most circumstances, as long as my beneficiary is under the age of 65, and put it into a special needs trust. But it's a first party special needs trust that is subject to a mandatory Medicaid payback. What does that mean? It means when my beneficiary dies, Medicaid has the first right of payback. Medicaid in every state that has ever issued benefits has the right to be paid back up into the entire amount in that trust. Now, why am I harping on this? because first party money in the terms of an inheritance can almost always be third party money. If I've done my estate planning and instead of leaving money directly to Johnny, I leave it to the third party special needs trust for the benefit of Johnny, it's third party money and it's now not subject to a Medicaid payback requirement. First party money subject to Medicaid payback. Third party money not subject to Medicaid payback. So when a family comes to me needing special needs planning, I always start with their estate planning. Their estate planning has to include appropriate provisions for the special needs child to catch that money and hold it in a third-party special needs trust. Otherwise, if the beneficiary becomes entitled to a direct inheritance, either because mom and dad never did their planning or because the planning is insufficient, that beneficiary, again, as long as they're under 65, I can probably still catch it so that my beneficiary won't permanently lose benefits until that money is spent down, but it's subject to Medicaid payback. Now, I'd still rather my child get benefits and have to deal with the Medicaid payback, but I'd rather not deal with the Medicaid payback at all if it can be avoided. And in the context of estate planning, as long as it's done properly, an inheritance, we've got that option to direct it to a third-party trust. Let's direct it to a third-party trust that doesn't have a Medicaid payback provision, so that at the beneficiary's death, to the extent money is remaining, I can leave that to other beneficiaries. Maybe I want to leave that to my other children. Maybe my child with special needs has children. I want to leave it to them. I've got all sorts of options with my third-party trust. I can still name those beneficiaries in my first-party trust, but Medicaid gets paid back first. And that's the way it should be for this type of trust structure. These are the rules. This is how we got it. When it's the beneficiary's own money, it's subject to Medicaid payback. I don't want to wind up there, though, unless I absolutely have to. And I don't have to in the context of estate planning, which is why, to bring it back full circle, when that family comes in to meet with me and they say, we need guardianship conservatorship first, I say, nope, we're going to do your estate planning first. Because if my clients are hit by a bus and that estate planning isn't in place, I've gone down first party trust land. Can't do anything about it. That's where I'm at. Whereas if my clients are hit by a bus and we've got the estate planning done, but we haven't decided on capacity planning, we haven't figured out powers of attorney versus guardianship and conservatorship for my special needs beneficiary, I can still do that planning. It's not going to be impacted in the same way the failure to do estate planning is impacted. So that's why we're doing our course today on basic estate planning. And that's why I gave you that quick and dirty version, first versus third, means tested versus entitlement, because it's important to understand all of those staples to get to why we're here now. So when we sit down to do our estate planning, I'm going to make sure we take everything into consideration, and all special needs planners will. How much money do you want to leave to your special needs beneficiary versus your neurotypical children? Where is the need the greatest? If you can't decide how to split the money up, we'll pull in professionals who can help you run projections to see what makes sense. Some families are going to gravitate to, I don't want to leave anything to my neurotypical children, everything for the benefit of the special needs individual. We may want to run some numbers on that just to make sure it's the way you need to go, because it still could be a very hard thing for your neurotypical kids to swallow when the time comes. Most siblings of neurodivergent or special needs individuals will say, whatever my sibling needs, I want them to be provided for, but it's still hard. And so before we make that very powerful decision to only leave money to our special needs beneficiary, we want to run the numbers and make sure it's actually necessitated. We want to make sure that the beneficiary is in fact going to have a shortfall, not made up by public benefits that can only be filled by inheriting the entirety of your estate. That's why we pull in other professionals as part of your estate planning. We pull in financial planners who can run projections, see if there's a shortfall, how much of a shortfall, how do we fill that shortfall in? Accountants who help us understand the tax consequences. What we're aiming to do is make sure that the plan we put in place is as effective as possible. One of the most moving experiences of my career, I had a client turn 100. I attend a lot of funerals. I don't get to attend a lot of 100th birthday parties. And when I attended this gentleman's 100th birthday party, he pulled me aside to tell me that when his wife died 15 years before him, the binder worked exactly the way the binder was supposed to. What did he mean by that? That binder that we had executed that sat up on the shelf with all of his estate planning, the documents worked the way they were supposed to when his wife died. That's the goal. The plan is supposed to work the way the plan's supposed to work. Because once there's been a death, we lose a lot of our options to go ahead and make changes. That's why conversations about honesty with your attorney, intimate discussions about what your children need, what they don't need, who are appropriate fiduciaries are crucial, because your attorney can't plan for you and make sure that that plan, which may not take effect for 20 to 30 years after you've executed it, does everything that you in fact need it to do. So when we're doing our special needs planning and we're setting up our third-party trust for the benefit of our special needs individual, and that's not to say there won't also be a first party. Oftentimes beneficiaries have both, but I don't ever want that third-party money to become first-party money just because of lack of planning. We're setting up our third-party trust in the context of our estate plan. One of the first conversations we're going to have is pooled or standalone. What do I mean by that? Well, you've probably guessed at this juncture, I like breaking things out into two. We can set up two types of special needs trusts, a pooled trust and a standalone trust. Both are special needs trusts. Both preserve benefits eligibility in the same way. Both contain that language that this is not an asset that is available to the beneficiary. Can't compel a distribution, can't tell the trustee what to do. Great. No access or control, not a resource. We've cleared that hurdle. Let's talk about the two types of special needs trusts and how we can use them. A pooled special needs trust is a trust administered by a nonprofit organization. That same 1993 Omnibus Budget Reconciliation Act that gave us these trusts gave us pooled special needs trusts. Nonprofit organization that has a master trust agreement that allows for the creation of sub-accounts underneath that master trust agreement for the benefit of individual beneficiaries. The money in that account belongs just to your beneficiary. No other beneficiary can access it for their care or support. But for purposes of investment, the money is pooled together. So instead of investing $200,000, we're investing $97 million. Our rate of return is going to be much higher. Given the amount of money, we're going to be able to withstand market fluctuations a little bit better. And then we're going to get professional management at a fraction of the cost, because the fees for our nonprofit and our trustee are going to be divided, and our investment management are going to be divided among each of the separate sub-accounts. So we get professional management with a higher rate of return at a lower cost. Pools are a fantastic option and not one that a lot of special needs families know about. Not a lot of attorneys are going to tell you about them, because attorneys don't make a dime when clients opt for a special needs trust run by a pooled organization. If I draft a standalone trust, which I'll talk about in detail in a moment, I get a fee for my work. There's no fee associated with the pooled special needs trust. And that's why it's so important to work with an attorney who knows special needs and knows what a value add pooled special needs trusts are. They're a fantastic alternative. Not all families go with them, but it's important that we investigate them so we can determine whether or not it's an appropriate fit. If it's not an appropriate fit, that's fine, but at least we've ruled it out in a way that makes sense. So now let's talk about the standalone special needs trust option. Standalone trust, as I just mentioned, is something a lawyer like me would draft. We take in information from the client. That trust is signed, dated by the grantor, person creating it, and that trust springs into life the minute it's signed. I tell folks to think of trusts as invisible third people who are created the moment that they're signed into existence, and they have to live according to the terms that the trust agreement sets. So, when do we want to use a standalone trust versus a pool? Well, one huge qualifier is the amount of money going into it. I apologize for my camera glitching. Hopefully the audio is still okay. For pooled special needs trusts, there's not a minimum. It's whatever amount of money you put in. For a standalone special needs trust, there's no minimum either, but there is a minimum amount that makes sense. Trusts are invisible third people. Once that trust is funded, it's going to have to do things like file tax returns, pay trustee fees, keep records of everything it's doing. If that trust is funded with less than about $1.2, $1.5 million, the income the trust generates, I tell folks to think of it like the interest. The income the trust generates is not going to be enough to sustain the cost, which means we're going to dive into the principle of the trust, the money in the trust, that original amount that you left for your loved one to pay off costs. We generally don't want to do that. We want to preserve the money for the benefit of our loved ones so that they get the maximum benefit from that money. If the amount in the trust is being run down on a regular basis in fees, expenses, costs of administration, we're doing a disservice to the beneficiary. So it's important to have that conversation with your attorney. Is this appropriate? Is there enough money going into this trust to make it make sense? Next is the question of who's going to administer this standalone special needs trust. Most lawyers aren't going to have a conversation with you about naming a professional trustee, somebody that just does this and nothing else. And they're going to say, who do you want to serve as trustee? You're going to give them Uncle Bob, and they're going to write Uncle Bob's name in. Uncle Bob can probably figure out how to administer almost any type of trust. I'm going to allow me to walk that back. Uncle Bob can probably figure out how to manage your standard revocable living trust. Uncle Bob probably should not be figuring out how to manage a special needs trust. There's two types of trusts when we're looking just at trusts in general: simple and complex. Special needs trusts are always complex. Uncle Bob should not be trying to figure this out, because if Uncle Bob does something incorrectly with the trust, makes a distribution directly to the beneficiary instead of directly for the benefit of the beneficiary, or fails to file tax returns, or doesn't manage the investments appropriately, who's going to pay the price? It's going to be your special needs individual. And oftentimes the person paying the price is the person least capable of paying it. When we talk about third-party standalone special needs trusts, I always recommend folks strongly consider utilizing a professional trustee. That's one of the big reasons we want to make sure there's enough money in there. We can't run the risk that the trust is going to be administered inappropriately. Don't want to run the risk that we're going to eat away at the corpus. We're going to eat away at the money in the trust by paying for expenses associated with the trust that the income is not enough to handle. We want to make sure there's longevity. Is that trustee going to be there? If I'm setting up a third-party standalone trust for the benefit of my child is 50 when I die, and that trust funds through my estate plan, that trust could go for 30 years. Is Uncle Bob my age or older? Is Uncle Bob still going to be here? Have I named an appropriate number of successors? All of these are questions you want to walk through. A lot of times clients will walk into a general practitioner's office and say, I need a special needs trust for my special needs child. That general practitioner will pull a form out of a book and draft it, and you'll think everything is done. Well, first we got to hope and pray that the general practitioner picked the right form, because I can't tell you the number of times I've seen that practitioner pull a first-party form for what should be a third-party trust. Then we have to make sure the trust is going to do what we think it's going to do. Is there enough money to sustain it? Is the trustee an appropriate pick? All of these questions. Where is the beneficiary going to live once you're no longer the one taking care of your beneficiary? Does the trustee have the authority to change the situs of the trust? Trusts are invisible third people. They have to live someplace. We want to make sure the situs where the trust lives can be changed and moved as we need it to. All of these are things that a special needs practitioner can walk through with you when deciding, okay, do I need pooled? Do I need standalone? What makes the most sense? So you've come in, you've met with the attorney, you're doing your estate planning because you recognize this is the piece that comes first. You've recognized, okay, I need to make sure that Johnny gets third-party money. So I'm setting up a special needs trust now. We third-party trust, and I've gone with a pool or I've gone with a standalone. Doesn't matter. That trust is going to fund through the terms of your estate plan. What do I mean by that? Well, we typically recommend that that special needs trust lay empty until the time it funds with your estate. Now, again, there are going to be caveats and exceptions to everything. But during your lifetime, if you're Johnny's parents, you are the special needs trust for Johnny. As long as you're alive and providing for him, you're paying for the things he needs. That special needs trust ideally is not going to fund. That means taking money into it until you're gone. That's when we need the trust to activate as our invisible third person, start doing all the things that trusts should do. Now, you can fund it early, but just please keep in mind if you do that, all of those requirements start at that juncture, especially for taxes, for reporting to benefits agencies. When that trust funds, benefits agencies need to know about it. So if you do that prior to your death, very, very important, you let Medicaid and Social Security know there's this trust. Doesn't have anything, it's not functioning fully like it will when I'm gone, but since I've already put money into it, need to make you aware of it now. There's a lot of requirements that flow with that trust. I'm of the opinion, absent a compelling circumstance, I've got my plan all lined up, done, dusted, beautiful, ready to go, but I'm not going to fund it until mom and dad die. And then my wills or my trusts, which are my dispositive estate planning documents that pass my wealth at my death, are going to direct to my third-party trust for the benefit of my special needs individual. So it's going to flow to my pooled special needs trust. It's going to flow to my third-party standalone. It's going to flow in the proportion I set for it. How much of my estate? 20%, 50%, 100%. Just lay out your percentages very clearly so we know how much is flowing to your special needs beneficiary, how much is flowing to your other beneficiaries, if any. Really important, and I can't stress this enough, that the special needs trust is named correctly. I know that sounds like a silly thing, but the number of estate plans I've seen that do not properly name the special needs trust is startling. And the money has to be distributed to where the money says it is supposed to go. This is why we want one third-party special needs trust in most circumstances. I want mom and dad to have created one third-party special needs trust. Either it's a pool trust with an organization like the ARC CCT, Shared Horizons, that all family members use, or it's a third-party standalone special needs trust that all family members use. I want one structure holding the money everybody wants to leave for the benefit of my beneficiary. I want my lawyer to have told me exactly how to name the trust. It matters. If we name the trust wrong, there's a very good chance we can't get the money intended for Johnny into Johnny's special needs trust easily. Got to be named correctly. If you have any doubt, ask. It's very, very important, and it's a common mistake. So you've done your powers of attorney, you've done your estate planning, you've either chosen to go with a will that funds a special needs trust, or you have a living trust for you and your spouse, or whatever your conglomeration is that passes the money to your third-party special needs trust. Some typical practice pointers I like to offer: always recommend using a trust to fund the special needs trust. So my husband and I have Crane Family Trust. If we're funding a special needs trust for the benefit of one of our children, the funding is going to happen inside the special needs trust. I hereby leave 1/5 of my estate, or 1/5 of my trust estate, to the Johnny F. Crane Special Needs Trust, established under agreement, dated October 24th, 2024, 2023. Pick your year, whenever you execute it. Why does that matter? Well, wills are public record and trusts are not. If I were to give you the name of my father or my mother-in-law and you went down to the Prince William County Courthouse or the Fairfax County Courthouse, you could pull their wills. They're public record. Trusts are private. Nobody else sees them in any public place. And so when I have a special needs individual, I like to make sure their identity is protected. I can protect their identity much better in the terms of a trust than I can under the terms of a will. Additionally, wills are subject to court supervision, reporting requirements. Trusts generally are not. All of these are meant as practice pointers to talk through with your lawyer when you sit down to decide, what is my estate plan going to look like? I've got powers of attorney now because I understand why it's important. I know that I have to pass my money when I die via a will, via a trust, and I know I need to pass it in a protected vehicle for my loved one. I know that I don't want money that doesn't have to be subject to a Medicaid payback to be subject to a Medicaid payback. So it's going to be third-party money. I'm going to get that trust set up now. And it's either going to be a trust with a pool or it's going to be a standalone. And if it's a standalone, I'm going to make sure I've ticked every single box so that my beneficiary, the person who can least afford to suffer a misstep, everything's going to get up and running like clockwork. If I've hired a corporate trustee, that trustee has a plan for how the trust is going to get funding immediately, because estate and trust administration takes a while. How are we going to get money into that third-party trust right away? We've worked out a plan. If I've named a family member as trustee, I've got a lawyer waiting in the wings to help them if they need assistance. That estate plan is the crucial first step in making sure your loved one with special needs is provided for. It's also the crucial first step in making sure you're provided for. Special needs parents have a tendency to put ourselves last. I've shared with, countless clients and members of the community that I'm a mother of 5, and my son was born with a cleft palate, deaf, and with heart and kidney disease. His needs always come first, and I can be on death's door with COVID or strep or pneumonia, and I won't go to the doctor. And my husband will always have to stop me and say, why aren't you going to the doctor? And I'll say, well, because Joe needs this, or one of the kids needs something. And he'll remind me, you have to take care of yourself too. So that's what I try to do for clients and family members that I work with. We have to take care of ourselves too. And we take care of ourselves in part by making sure our estate planning is done, it's up to date, it's reviewed on a regular basis, and we take care of our loved ones with special needs in the terms of our estate plan by making sure we've planned appropriately for them. We make sure that our fiduciaries, the people serving us, have access to our documents, know where they are. We make sure our documents are up to date. We make sure they've been reviewed. We make sure the trusts that are named are easily identifiable and accessible. We make sure we don't have handwriting on any of our documents. We make sure we have exercised all the pertinent practice pointers so that when the binder needs to work, when that time comes, whenever it comes, how far from now it comes, the binder works the way the binder intended. I usually tell folks estate planning is not an area where you want to bargain hunt. It's not an area where you want to try to save money. It's an area where it's important to pick a practitioner you're comfortable with, who will do what you want done, who will understand your wishes, have the expertise and the experience to help effectuate your wishes. This is usually the point in a live seminar when I get the question, Jen, how do I select an attorney that's a good fit for me? I tell folks to call 3 attorneys in their geographic area. If you need a special needs attorney, make sure they actually do special needs. It's one thing to say you do special needs, and it's another thing to actually do special needs. Make sure they have the credentials to do special needs planning. Make sure they've been a practitioner for a while. Make sure they're willing to talk to you for free for 10 to 15 minutes to make sure that it's a good fit. Estate planning is an incredibly intimate area of law, and it's important to make sure you feel comfortable talking with that person. Make sure you ask about the rates up front. Lawyers are expensive friends to have, and you want to know what the price is going to be walking into it. Does this attorney do hourly work? Do they bill flat fee? How does the structure work for ongoing review? Ask those questions now, and then sit down for your consultation. Make sure after you've winnowed your 3 down to the one you want to meet with, you're going in for your consult, do what the lawyer asks. If we send you a bunch of forms to fill out before you come in, I promise it's not because we're masochists. We need the information so we can better plan for you. If we don't know, we can't plan, and then we can't be of service to you. It's been an absolute pleasure to talk with you this morning about the basics of estate planning, the basic structures we like to see in place, and to give you a 30,000-foot view on entitlement versus means-tested benefits, first and third-party trusts, as well as pooled versus standalone trusts. If you have further questions, I highly encourage you to reach out to the ARC, any entity you feel comfortable contacting to start on the path of proper planning for yourself and your loved one.